And we are looking at a draft number 1.1 of H 105, starting with legislative council. Over to you, Ben.
Thank you, Chair Lalonde. For the record, Ben Novogroski from the Office of Legislative Counsel. Before the committee is draft strike all amendment to H 105, where the changes are highlighted for convenience. There will be a clean and edited version forthcoming momentarily to be posted and viewed at your pleasure. So the first section, you'll notice changes to the minimum age, as was discussed last year. So it's no longer 10 years of age or older. It is now 12 years of age. And from my memory, the committee discussion said that that would align with H2. So it's an attempt to be consistent there. Also, just a couple sort of technical organizational changes that are non-substantive as far as reader assistance heading. So striking penalties and moving that term farther down to where it's more appropriate. You'll see also prohibited conduct to change from 10 to 12 years of age on line 13. And then scrolling down, again, changing the reader assistance heading from underage to procurement because it's more accurate and reads better. And then you'll see on lines 16 and 17, just to clarify that someone who fails to complete the Youth Substance Awareness Safety Program commits a civil violation under the jurisdiction of the Judicial Bureau. So it would go before the Judicial Bureau and be subject to the following, which the penalties do not change in this instance for failure. You'll see subdivision 3 on the next page, changing on line 4 to impaired driver penalties, and some grammatical changes and clarifications as well. So what the big change in this portion does is it creates an automatic suspension for someone that commits an impaired driver penalty. So someone who commits such a violation is referred to court diversion program for the purpose of enrollment in the Youth Substance Awareness Safety Program and shall serve, so this is on line 8, and shall serve a suspension of the person's operator's license and privilege to operate a motor vehicle in accordance with subdivision B of the subdivision 3, which will go into the terms of those suspensions. And then again, some clarifying language on line 11, that's a civil violation within the Judicial Bureau's jurisdiction. So you'll see on line 20, just a change to a cross-reference to make it more accurate. And then if you scroll down to page 5, you'll see on line 6 and 7 that the program fee cap of $100 has been struck. And rather than a charge of violating, that has changed to an alleged violation to be more precise for how these would occur. And then the addition of this subdivision B is the term of suspension. So for the first offense, a person shall serve a suspension of their license for a period of 45 days and shall be automatically reinstated after the 45-day period. For a second or subsequent offense, the suspension is for a period of 90 days with automatic reinstatement after that period. I would just flag for the committee that something that probably should be a source of discussion is how the mechanics of how these suspensions work. So for instance, in 23 VSA 1205, which is the civil suspension statute for DUIs in general, there's a notice of intent to suspend that's issued that would go into effect on the 11th day. So just sort of some mechanics language, and then what the process would be to notify DMV, which we've kind of addressed in some other bills. But I wanted to highlight that for the committee, that's something that may be discussed, and the language already exists in one form or the other, so it's not a huge deal to replicate it in the way that the committee would see fit. So just
let me ask the question then. So is this in conflict with that language if we say automatic suspension, or is it understood that that means going through that process that's in the other?
If memory serves, I think 1205 is connected to a violation of 1201. So this is separate and apart. But clarification never hurts if you so desire. But I believe that 1205 is considered a separate track from these because it's this is exclusive for those 21 and younger.
So to make sure we have this right, should we have DMV talk to us about this? Is that who would be able to weigh in on?
I mean, part of it would be, so the notice of intent to suspend would be issued by law enforcement. So that would be a form that they would have to then hand to somebody. I also think that the Attorney General's and Department of State's attorneys and sheriffs can weigh in, but as far as what the DMV may want to see as far as specific documentation, probably a good idea to bring that in.
Yeah, okay. All right.
Oh, so moving on, you'll see on the top of page 6, subdivision 3, that if someone fails to complete the program, the person shall receive credit for any elapsed period of a suspension served pursuant to the previous subdivision against any suspension imposed pursuant to subdivision A of this subdivision 3. So basically what that's saying is that anytime you serve for that automatic suspension, if you fail and now you have to, you're subject to the penalties in Judicial Bureau, any time served for that initial suspension will be credited to the suspension that you receive as a result of that failure. And then a cross-reference cleanup on line 5. And then again, just changing from the automatic reinstatement in these provisions since it's addressed previously and in a different context. And I believe that is all of the changes for the committee. Yes.
Questions for Ben?
Just a moment. So pages like basically 1 through 5.5. So that
No, these are all within the jurisdiction of the Judicial Bureau. Yeah.
Judicial Bureau civil.
Mhm.
You're gonna
The only difference between being compliant with the program and failing the program is the length of the suspensions and the fines that are associated. Because you don't get fined if you're
the
in the
verbiage on
program.
the intent to suspend form. That.
Right, so you typically what would be drafted.
Civil.
Say that again.
Suspend. The civil form of intent was. Criminal verbiage in it.
Correct. Yeah, so it would just have to, what I was mentioning before about 1205 is that such a structure exists. It would just have to be tailored for this statute. So you're not exactly reinventing the wheel, so to speak, because it's already a process that law enforcement does. It's just for a civil process.
Yeah, we do it for a criminal.
Right, exactly. So this would be a exclusively civil process.
I just,
Yeah, go ahead.
but we're saying we probably need to add some language. to
Yeah.
get at that.
Yeah.
Yeah, that's why, because I know the
Okay.
form well and
Yeah.
it's not guided.
Because, there was a brief conversation with Willa and Kim earlier. It's like, oh, could this just be a cross-reference to 1205? And I think this is showing that probably not. That you could use some of the language from 1205 to put into here, but tailor it so it's a civil penalty rather than tied to a criminal.
Well, there's a down the bottom of the form, also 11, 7, and 7, If the intent to suspend, when you have your notice by.
Yep.
And your citation date is between 14 and 21 days
After, yeah.
after issuance, right? So I'm just like,
We're gonna add something that clarifies.
Well, I mean, a lot of times, this would be drafted in such a way that, the Office of Court Administrator or something like that shall create forms, in accordance with this section, something like that. You can get more specific, but that's one way you can do it. That is.
so, but you can still go down to 1201.
Right, this does not prohibit a charge under 1201.
So it's anything 08 or less than 08 or influence. This is everything other.
Right, I mean, but you could also still be charged criminally if you're charged civilly under this. Yeah.
Right. I get that.
Yeah.
But I mean, typically, if this is not, this can be charged for anything that's not carried criminally too, right? You could do this up until 08,
Mhm.
or if they're, well, up until 08, because if they're under the influence, then you could have a criminal check, but
Right,
on 07, I could push one of these.
so they could do that, but they could still charge under the influence, under 1201.
Yeah. Well, if they're driving bad, but I don't have.
Right, exactly.
Yes, right, but I mean, if I don't even go down that road, I could still go civil.
Mhm. Yes. It provides another tool, if you will.
Other questions?
Representative Harvey, it looks like you have,
An idea for.
you're working on something.
Yeah, I'm working on something. No, this is actually, just, well, I guess.
So go ahead.
To be recognized. Just to make sure I'm understanding this right, so we landed on 45 days,
For the first,
for the initial suspension.
yes, and 90 for the second.
Okay,
So that would be automatic regardless of failure out of the youth substance awareness safety program. So what it would be is that you enroll in that program.
Right.
And you get suspended. The suspension would increase if you failed out of the program.
okay.
45 days.
So we can hear from some witnesses on that. That's not definitive whatsoever. It's thrown out there for discussion.
So it's a starting point.
Exactly. Well, it's the second point after the starting point. As introduced. So,
The
yeah.
first, we started at 9.
No, we started at nothing.
At nothing,
Yeah. Yes.
So we're getting closer.
The only suspension would, in the as introduced version, came if you failed out of the program.
Right.
Yeah.
Yeah. So the 90 days or the 45 days goes to the 180 if you fail completion.
Yes.
90-day goes to the 1 year.
Yes.
So we'll hear from witnesses, but theoretically, someone could, if we borrow, I mean, the language from 1205 subsection C seems like exactly like what we use on the notice. You get the notice, your suspension will go into effect immediately. If someone wanted to do no compliance with the programming, they would basically just, their license would be suspended for 90 days. And then when 90 days lapsed, there would be some sort of understanding that they didn't complete the program. Their license would continue to be suspended for the.
Well, I think that's part of what the discussion would be
Or
about, sort of
45
the
days.
mechanics of how that would work.
Okay.
Yeah.
Yeah. Okay. Because, could it be that? No, okay, I understand. Thank you. Yep.
Anything else for Ben? Not seeming, we'll hear from Will on it.
You want me to leave this up on the screen, Phil, when I move over to the desk?
No, I take it off.
Okay.
We can see witness. Good morning.
Willa Farrell, Attorney General's Office, Court Diversion and Pretrial Services. Thank you for opportunity to speak on the revision to H-105. In short, I agree with the changes that are proposed here. I like that we're retaining the overall goal of the bill of having a fast and speedy intervention and one that is simpler, that makes sense to youth, law enforcement and program staff. My only question really was the mechanics of how that immediate suspension would operate. I think that it's important, whatever the legal niceties that are grappled with, that the process be simple and really clear to youth, and that it be fast. I think it's important that the consequence happen quickly. I started to chew on some ideas just listening to this last discussion. And so while I'm not familiar much with 1205, I do think that may be possible to include in the notice of violation, that initial notice of violation, that goes to the youth, I think it would be important for that to include the suspension information that aligns with whatever separate process might happen for that immediate suspension. But I'm happy to work offline with others about, how the ramifications may play out from what I hear. But in short, support the concept and the provisions as laid out in the bill.
Aaron and then Tom.
I'm good for now.
Okay.
Digesting.
Okay. Karen.
So I'm curious your thoughts on the suspension. I don't know if you heard our committee discussion that we had on this last week of trying to find the length of time that makes sense. And I'm really looking for data that's informing it.
Yes.
I think there's also like, how do we align it with what already exists in statute? But I'm like, so like, do we automatic? And so I guess any input you thought, because for me, I want to do the minimum amount that has the impact.
Yes.
And so is that 45 days? But actually 30 days would work. And then I think you're getting what I'm trying
Sure.
to get at. If you have any insight on it, and I think I'm going to ask this of all the witnesses that we have, so we can try to see, are we getting at the right numbers?
I think it's really hard to know what the right number is. Probably, not to state the obvious, depends on the individual. From what I've seen in the literature, the most effective intervention for people who drink under the influence is treatment. Suspensions have effect, while in the short term is sort of what the kernel I took from what I've read. So I think a suspension is important. It's directly related to the behavior. It's a logical consequence to the behavior. And I think it is understandable to a person why their license would be suspended in that context. I think a shorter period of time makes sense for shorter. Now I can talk more about numbers in a minute, but in general, a shorter period of time, I believe, makes sense because this is a lower level. If it's higher, that the officer would charge as a criminal offense, and then there's more serious consequences. What I jotted down were the different suspension numbers, because I think part of what the numbers should appear to have a sequential or escalating length depending on the severity of the offense or the lack of engagement. So if a person engages in the program, it's 45 days for their first offense as proposed. If they fail, it jumps to 180 days. So there is a significant longer, harsher consequence, if you will, and one that also serves as a motivator for the individual to engage in the program, which I think is important because this is a faster intervention program than what IDRP would be, which would be required should they fail. There's a second offense again. Then the failure goes that if you fail under this proposal to engage or fail the program, it's a year or until you're 21, which is, I think, a logical increase in that. It's the second time that's, to me, significantly more serious. And then but if you engage in the program, it is only 90 days, but that's still twice the suspension than on your first successful engagement. I should have done this in a different order. I hope I'm not totally.
No, I follow.
You're following. If you compare just the simple possession versus the 0.02, the simple possession, if you fail, is a 30-day suspension. So that is less than should you either engage or not engage regarding a 0.02 ticket. So the lengths ratchet up depending on the severity of the violation. You started by asking me the actual data on numbers. I was not able to find anything about the research. A suspension of this days compared to a suspension of this length has a different effect. I wasn't able to find that detail.
But the thing that I'm hearing you say, because that's what I think there's a gap in data of like, what
Yes.
is the suspension? But a piece that I'm hearing you say is that that progression is important, I
Yes.
think, for service providers, but also for youth to understand.
Right.
It's not just randomly you're getting suspended, that it's connected to the severity of the behavior.
Right.
So, okay.
I was struck last week when Kelly Ahrens from the Burlington CJC testified, and she said she's had youth say to her, you mean if I had had more alcohol and gotten a 0.08, I mean, a DUI above 0.08, my suspension would be shorter than for this civil violation where my alcohol content was 0.04. And so that's the illogic of the system that undermines the credibility of the intervention. So I think credibility, the whole concept of procedural justice and credibility to the person who's like engaging in the system is really important for it to be effective.
Other questions for Will? So, seeing, so, thank you very much. So we'll hear from, Kim next. And Kim, you can certainly weigh in on the whole bill because I don't think, DSAS has had a chance to weigh in on this yet, if I'm remembering right.
Good morning, everyone. For the record, my name is Kim McManus. I'm with the State's Attorney's and Sheriff's Department. Good to see you all. As you can probably tell, I am not Attorney Wigmans, who is our DUI expert. So I'm happy to review the bill and give you our position that Dennis has informed me of what our position is. If we start drilling down into really complicated DUI, civil and criminal questions, I will take the best notes ever and I will send you an email later today outlining all the answers. But I'm not fluent in DUI the way Attorney Wigmans is. But our general position is that we do support the bill. We support the goal of this expansion of the Youth Substance Awareness Safety Program. We very much wanted the suspension to be coupled with the intervention. So this current draft, we absolutely support that, and we support the immediacy of that suspension. And as your legislative counsel pointed out, the one question we had in our note was just that to button up that process. And we fully believe that once this committee decides, if it's immediate and what the dates are, when you all make those decisions, that legislative counsel will be able to word that using sort of pre-existing statutes, but making it appropriate for this section. And as pointed out, whether DMV needs to be brought in as far as that process of reinstatement, and again, where the paperwork's going and who's doing what. Just that piece we noted, but otherwise we support the suspension piece and just believe that is incredibly important. That immediate consequence is there, that very tangible consequence, while the youth is then engaging in the education. To your question that's probably coming, I'll just go ahead and jump in there. As far as the number of days, we do not have a strong position on that. To what Ms. Farrell said, as long as it's making logical sense across the board, we really do appreciate when incredibly savvy youth are like, are you kidding? This doesn't make sense. And just that undermining, as stated by Ms. Farrell, that is so incredibly important. So as long as that piece makes sense, that makes sense on our end, I would, and then the escalating piece also makes sense, but whether that's 45 days to 90 days or 60 days to 80 days, that's really up to you all.
Anything else on
No, the other piece that we know changed, but we also have no issue with is the 10 to 12, so no issue there, so. Yeah, we're happy to work with legislative council, if there's anything needed as far as that notice piece. We can have our DUI specialist, check.
So just to make sure clear, you're ambivalent as far as what those delayed, the suspensions are, or did I miss that?
I don't know if ambivalence the right word. I wouldn't have a argument to raise or lower those based on what the question had been as far as, connection with data and what sort of timing consequence is going to have an influence on a youth. So we have no strong feeling about the number of days. The immediacy, I think it's important. I think a significant amount of time is important. And for a youth, 45 days for an adult goes in a second. 45 days for a teenager would feel like a lot of time, I would imagine. The one thing I would just maybe raise again to make that logical connection, and Ms. Farrell may be able to speak to this, is I don't know the timing of the referral and starting the program and getting engaged in the program. And I would imagine you would want a youth to be a bit of a way through the program before being able to get their license back. Like, I wonder how much you'd want to attach how far through the process they are with that. Again, if someone who's a bit savvy knows that they can stall a bit and they know they need to finish the program because they don't want the big consequence, but they can get their license back no matter sort of when they start, that might be something to consider.
So I guess I will ask Willa to comment on that. Is what is, how long does it take to get into the program?
There are some youth who receive violations who might complete the program within 40 days if they contact quickly and they get in certain areas with caseload. So sometimes it's the program may not be able to respond as quickly, or it may take longer for the youth or family to get the youth to the program. So long-winded way of saying it depends. I see can't think that to Ms. McManus point about time completion. So I could see an argument to be made that I'm immediately going to mechanics, but I think there's an argument to be made that suspension ends upon successful completion of the program, but is at least 45 days, something along those lines might. Again, but I guess that my only caveat there would be to make sure that it's doesn't add to sort of bureaucratic churn on this part. So I guess again, mechanics may be hesitant.
Karen, Nadia.
So I appreciate this piece of it because I think there are those folks who will look at it and work it. I just hesitate to create a program that works to serve those few individuals are doing versus the majority. Because I also think that it would put pressure on our programs that are doing it, like what if they're running short on time or like, I just feel like it creates a weird dynamic. So for me, my preference would be to start with something like this and then let's get data on it to see where are the cracks, where are the gaps on it to rather than creating the program for these exceptions that we think might happen. So, because I'm guessing what I'm hearing, that it would be a small number of folks that would fall in this category.
I think the number of referrals we would get would be small to start with, just based on, if I'm remembering correctly, the Judicial Bureau last year had 40 adjudications for .02 violations. So we may get 40, maybe we'll get more, maybe officers will issue more, I don't know. So we would have a small end to start with, but haven't worked with that around that issue in the past. We could certainly come back and give you a breakdown of how long how many people completed the program in this time period versus that time period, or
in more details. Maybe it's asking for that reporting to trigger for us to reevaluate and look at it. Yeah. Yeah.
Yeah.
I think the only thing I was gonna say was, we had some discussion about linking it to the, program completion, the suspension, but it creates this really tricky thing with people then like rushing the program or, and I think that this language, we still sort of keep the carrot and stick structure because even if, you know, in instances that you're talking about, where maybe it takes longer and a youth's the license would be suspended and then they would be reinstated, but they'd be in the program, it'd still have the sort of weight of the, and if they didn't complete it, their license would go back to suspension. So,
Yeah.
but I hear that point, and I think it's an interesting idea to include some language about reporting in this.
Sure. Follow up with that on. If that's okay. Yeah,
Are you looking at me?
Yeah, yeah.
Oh, do you want me to, yes, I can do that. Yes, okay.
Can work.
I can't tell, having a witness right behind me, I can't.
Well, no, actually, I've worked with Willa as well. He can help between Willa, you and Ben.
Sounds good.
Okay, so any other questions for Kim? I don't see any, so we'll go to Lindy.
Thank you.
Bro, thank you for being here. Nice to see you again.
Good morning, thanks for having me. For the record, my name is Lindy Boudreau. I'm the Adolescent Services Director at DCF Family Services. So overall, DCF supports this bill. It's, as Willa mentioned, one of the key factors of this bill is that it offers an immediate response to youth in relation to the incident. And that's certainly something that we know research shows provides opportunities for better outcomes for youth. So if a youth is going to go through the judicial process with like a possession of malt beverage, for example, it takes much longer. So this offers an immediate systems response, support and treatment to youth that we support. I also agree with Willa in relation to the question that the committee posed regarding the kind of magic number, if you will, for suspensions. That's really hard to kind of predict because, as Willa mentioned, some youth, it could just the idea of having any suspension is going to be an immediate deterrent and motivating factor for youth, whereas others, it may not have the same impact. So having a longer term for those youth may be what's necessary, but it's really hard to tell. So I think, as Representative Dolan was just speaking about, giving a period of time to kind of see, to look at the data and see the outcomes might be beneficial to see if there needs to be a modification in regards to the suspension or the number of suspensions. I also agree with Willa that having the an escalating kind of as the behaviors increase, having an increased response to number of suspensions is the appropriate way to go. Again, the number has yet to be determined, but I think the committee could certainly consider different dates if that's something that you feel is necessary. I can't really weigh in on that because in the family division, we don't deal with suspensions for youth who are charged criminally or in family division for DUI, their license is not suspended. So this bill actually offers more opportunity for the youth and immediate systems response and support, and also more accountability. I'm sure if anybody has any questions for me.
Any questions for Lindy on that? I don't see any, so thank you very much for that as well. So we have 45 minutes. We can talk about this bill, or we can actually reach out. Do you want to reach out to Todd Delos and see if he can come a little bit earlier, like about 10 o'clock? So where are people with 45, 60, 90? Anyone? Karen?
I can start. So I mean, I was the one that threw out the 10-day before, so, which is fine starting with, but after hearing from folks, I feel like, this is a good starting point. It makes that logical sense. It goes along with severity of it. I do think having some type of report back data for us to see, because this is brand new, we're creating this new system to be able to see and evaluate, would be helpful. And I think adding the mechanics piece to it. So I'll be curious to just, and you made a note that we might need to hear from DMV,
We're trying to get DMV in by tomorrow.
but
Tomorrow morning.
so
Find the right person.
that I am not asking to have us go back to 10 days or anything. I think I can go with this format.
Tom, do you have a view on that yet, or still contemplating? Or you still have other issues with this still? Or is that with the mechanics that we haven't?
I have some issues with the mechanics, but that's, I don't know, like, that can probably get ironed out. I think a 45-day suspension is not nearly enough.
Would you want 60 or 90?
It's gotta be at least as much as what they get for a moving violation. This is far more serious than a moving violation in a vehicle if you're driving around intoxicated. And you're probably having, you're probably earning some of those tickets at the same time. So I don't like it.
So I'll just throw out, and I'm just counting votes right now, just seeing where we're gonna end up, frankly. But I think the argument for 45 days, that's different than the 90 days. There's a couple arguments there. One is that you're not just suspending the license, you're making the person go through probably several meetings. You're putting obligations on the person that they're not having when they do a moving violation. So that makes it a little bit different. And also the fact that a 0.08 is 90 days. And again, this is the 0.02 would also point to 45 days. But having said that, so I've got you down as a 90-day person.
Maybe we should increase 0.08.
We should.
That could be another day.
And I understand that you give some incentive to do the programming. What if programming didn't work? I mean, they got away with it. I don't know if they go through the motions.
Right.
No.
Angela, do you know where you are?
I don't know what I would really base a solid opinion on. It feels a little bit like guessing, but not entirely. I hear Tom's point, and I fully hear and understand Karen's point as well. So
Fair enough. I'm with that.
But I just,
Yeah, I'm with you on that. I can frankly go either way. Alicia?
Same thing. I think it should be higher.
Ian?
Okay, so for a possession, you can get 30 days.
Possession, right.
Or if you fail, right? Is that the program? No, or you can just get a 30-day suspension. Doesn't matter if you're driving or not, you just get a 30-day suspension. Under this proposed language, first offense would be 45-day hard suspension with a 180 if you fail the program. Second would be a 90-day hard suspension with a year if you fail the program. There's also a 6-month suspension that I can't remember how you get it.
It's if you don't choose to do the program.
that's the.
No, I think there's another one.
bill. That would.
No, that's just an existing law. It's an existing.
That would be the refusal, wouldn't it, to participate?
Oh, we're talking about, no, I could be wrong. I just thought that there was one more suspension that currently exists, but I could be incorrect.
There's possession, the second time is 90 days.
It's 90 days. But again, possession has nothing to do with driving.
No.
So possession subsequent is 90. Okay, so I think where I'm at is, if that's all the suspensions, then I like at least that it's racking up. I think there's an argument to be made for it being totally random and we're just guessing and throwing darts in the dark. But right now, existing law, possession, you get a 30-day suspension and it has nothing to do with your driving at all. So there's some precedent here that we're trying to have some sort of consequence when it comes to youth and alcohol and using driving suspension as a tool. So I don't think we're like totally out of bounds using it here. I would be very hesitant to go longer than 45 days and 90.
Right?
You're hesitant to go beyond 90.
Or you're comfortable up to 90.
Well, we're talking about two different offenses. So I
I'm
think
talking first.
first, I wouldn't go up beyond 45 because we have there's no data that we're using.
The speeding tickets like that.
But a speeding
A stop
ticket
sign is like-
to Martin's
Road is like.
To Martin's point, though, a speeding ticket, it's just, they're not asking you to do anything. Here, we're suspending your license and we're asking you to go through
We
programming.
could send them through a driver improvement program. If you want to start going down that road, we could do this for everything. But we're not, and
Yeah,
it's making, frankly, I'm looking at, it's getting more complicated for us too. Not as legislators, as practitioners. It's gonna cost more money.
So I have another question, Tom. Do you think, would law enforcement be less inclined to issue a .02 ticket in these scenarios and just issue a possession ticket if it's 90 versus 45 days or?
Pick, right?
Right. Then I'm just wondering, what the,
You weren't 100% sure they were driving, then boom, you know where to go with that one.
right.
They're pretty agile at switching seats. But no, that's just,
Right, all right. But I'm just wondering the motivation of law enforcement would say, well,
you're gonna go with what you know you can get. I'm gonna take the safe bet versus the one I'm gonna have to really do a lot to articulate. And why do you want to go that far? If you're not gonna, it's just easier to take the one you know you can win.
right, so you definitely, you got the kid there in the driver's seat. I'm just wondering if law enforcement would impact their decision at all. It doesn't sound like it would, that it would be 90 days as opposed to 45 days.
Well, I don't know.
That's why I'm wondering.
Depends, there, I can see it happening, depends on the officer, I guess.
Right.
And how the contact goes.
Zach,
I'm with my colleagues on this one. Namely because.
My colleague,
My Republican colleagues, on that. I think it seems very counterintuitive to me that the suspension consequences would be less for someone who potentially could be driving without a license, is driving under the influence of alcohol, than someone who is licensed and is of legal drinking age. So I just have a lot of concerns about that. And again, it's not throwing the book at people, but I do think that I have concerns that offenders aren't gonna get the message with something as little as 45 days.
I think the program has gotta go either way, or it's gotta get it either way.
what do you mean?
I mean,
A mandatory.
yeah,
A mandatory.
even with the suspension, it gives them time to work on it too. I mean, I like the idea of the program.
Right. So.
may I add one thing?
Yeah, go ahead.
And I don't think we've had this conversation, but I believe there's data and research on mandatory programming and how it is not effective. And so if we just saying like we would want to explore that, the effectiveness of it, if that would,
It's not mandatory, it's just that you get another,
if we wanted to go down that route.
there's
Yes.
a stick there.
Well, we have mandatory programming in that domestic violence bill we're looking at.
It's not mandatory. It
Well-
may be added.
Maybe, but if they make you do it, then you gotta do it.
Right. And there are consequences.
If you don't, consequences if you
Criminal
don't,
charges.
yes.
You have consequences pretty clearly spelled out here.
So I guess one question, I guess, and this is for Tom, on moving violation, what is the suspension there?
90 days
Okay.
on
So
the
it's-
graduated license.
Ungraduated, so I feel like 90, sorry, well.
Yeah, go ahead, Will, if you
So
clarify.
I was puzzled by the suspension rate to speeding ticket, so I didn't know
to admit, I have had a speeding ticket, but it's been 10 years and I don't remember getting.
You had to have, on an operator's license, that's not the case.
Oh, okay, so the distinction, so if you're.
There's a difference on the driver's license.
And that's.
I'll look it up.
60.
Yeah, if you have the graduated.
I think there's a distinction there, because this also affects 20-year-olds. So there's broad age range. But that's
The
helpful
suspension thing would change at 18,
for a speeding ticket.
right? Because you get an adult driver's license.
Yeah, go ahead.
Which makes it, I think, a little bit of a false equivalency here to argue that the 90 days should be what we use for the suspension here, because there's a different element happening there. You're talking about an operator on a not permanent license. So yeah, they should probably have a pretty significant consequence if they're
That,
speeding.
I agree with that.
And so, that's a separate issue. And so, using that suspension timeline to then argue that for first offense here, it should be 90 days. I don't think it makes sense, because we could be talking about people with normal license, they're 18-year-olds or 19-year-olds and they're just driving, right? So
I'm talking about.
yeah, but that's a narrow subset.
Half of it.
Yeah, I guess.
We need data.
We're arguing around, we're not arguing, but we're discussing something with not really a lot of data.
Nobody liked 60 days, huh?
For the first,
split the
Not an option.
Sometimes that's in fact the way it's. Well, you actually look at other equivalents, and we're trying to look at other equivalents.
60 days.
But I think, like you said, of stuff that's already currently in statute, like working around that. So
I think we do it right here perfectly, we, thanks to legislative council and Karen's work, we have this nice sort of track up 30 days to 45 days to 90 days, and then 180 in a year if they don't successfully complete the programming. And it makes sense. It's logical. I think explaining it to someone who was in it, it would make sense.
If they've done it twice, I'm totally off board with anything. I mean. That's just, we're trying to keep people from killing themselves.
And if they do.
Or other people. That's the bottom line.
If they do it twice and
And I don't-
complete programming, their license is
Right.
free.
And I don't care. I mean, if it's my kid, I don't care. It's gonna be a pain for me as a parent and hauling them around, but at least I know they're gonna make it.
And not for other people.
So I will just also note that this is, as opposed to 180 days, that's under the 0.02. So we're still talking for a significant decrease if it goes to 90 days, plus programming. So, all right, I see where people are. That's very helpful. Thank you very much. And we'll have some more people in tomorrow, possibly to talk a little bit, including the law enforcement, the lieutenant, and I can't remember the lieutenant's name off the top.
Traveling?
Yeah, no.
Yes.
Was that what it was? Oh, sounds very much like the sheriff from
Oh, Gamlin.
Gamlin, yeah, that's why I was confused.
Pretty.
So let's take a 10-minute break or so until we see Todd show up.